Yeah. My name is Tracy Dunn. I represent the Small Matter. I'd like to reserve 5 minutes for
all right.
the original final point that there was 4 in the state friends and 47 world program and the issue of whether the claim is final. I'm bringing 3 questions to the board. 1, which is actually applies to the claim. 2, if it's 20 years on the DMV statute, whether or not violated. And 3, whether it has to fully comply. The timeline is important to start with that. If use occurred during the 2010-11 school year, we agree that it ended in June of 2011. The mother was not aware until June of 2013. The notice of claim was filed in June 2015, and the complaint was filed in March 2015. So the complaint was filed within 4 years of the mother being aware of use, but not within 4 years. The trial court found that the cause of action was proven in 2011, regardless of the fact that the mother was aware in 2013, and applied the general 4-year statute of immunity claim, not addressing our argument that it's actually Chapter 95 unlimited. Rejected our argument that barring can violate our courts and accepted the school court's argument that ethical ruling does not apply outside. So first, which is the right statute of limitations in the case, and our position that the trial court applied the wrong statute, that it should be section 95.11 of 9, and not.
What do you do with that language in 95.11 we talked about? The statute of limitations contained here will apply unless another one does.
Yes, Ryan, thank you for that question. And we want to thank the court for giving us notice that you wanted us to also discuss the Menendez that relates directly to that issue. So I'll get over the issue of whether section 95.11 of 9 applies to practice. I want to go back to that a little bit right into the how does this chapter 95 statute work with the 2 issues I think that regard. One is it's a different kind of described elsewhere, 95.11, then and 2, does the sovereign immunity statute always prompt and keep involving government? The 2 separate issues. Our argument is our voting, of course, keeping in mind that Menendez, the 1991 case, did hold that the 95.011, if another time described elsewhere, might in that case. So that's okay. We need to focus on a couple things. Number 1, 15 years later, the Supreme Court decided to agree. And number 2, in the Menendez case, for specific medical malpractice, number code, for the short window of time that actually is going to apply, the legislature already amended the statute. And in so amending the statute, the legislature has said, we're fixing this problem because we recognize that in med mal cases, the 95 statute wouldn't apply and the 70 would apply. So the court, as the court always does, looks to the legislative intent. And there that was now the legislative intent. Following the Menendez case, we have the Calhoun case, which is a case in the 5th district where the court addressed issue 2, Chapter 95 statute and the sovereign immunity statute, and said the sovereign said 2 things. Number 1, the different time elsewhere is going to control. And number 2, the 4-year period of sovereign immunity statute applies. Jump forward to the Green case, again, 15 years later, the Florida Supreme Court analyzed the Chapter 95 statute, the 1-year statute, and Chapter 78, the 4-year statute, and said that unless Chapter 95 applies to the case, Chapter 78 is controlled. And in so holding, the Florida Supreme Court in Green did not reaffirm the Menendez public health analysis and specifically disapproved twice in the opinion of Calhoun analysis, which is relied on the idea that under Menendez, the 95.011 language was wrong. If there's evidence of legislative intent, you would always go to the list. I think it's significant that in both the Menendez case and the Green case, the 768 statute of limitations was the longer statute. So we can go back to the general rule that we know apply. More recent also, in both cases, we know that there's restrictive order statute of limitations and there's a longer statute.
Okay, so maybe I just read, I'm trying to remember the case, but I read the liberal construction, because it made me scratch my head, but the liberal construction of statute of limitations and actually propels you to apply the shorter one. Did I read that incorrectly?
I would never want to say that you read anything incorrectly, Your Honor, but I think you can just look at the result in the Green and the Menendez.
Well, and I'm not talking about the Green case, right? Perhaps. I didn't. We've got quite a few names to work through here. One discussed the general canon of statute of limitations. It said there's two veins of thought, strict versus liberal. And as I read the case, the Florida applied the liberal construction, but liberality in this context means a shorter sentence. Is that true?
In the Silva case, it was only to the close. The statute of limitations that shortens the time considered strictly. And if there's reasonable doubt as to the legislative intent, we prefer the longer period. From the Silva case. I think that answers your question. There may be some cases, and where the difference in that you're referring to. But
okay, so I'm not coming out of left field with that.
No, yeah, there was a little bit. This was sort of the Supreme Court case, Silva, and it says two sentences about it. The statute of limitations that shorten the time is fairly improved, and if there's reasonable doubt as to what the legislative intent is. And again, it's only if there are two conflicting statutes, right, which is what we have here. We're going to give preference to the longer period. So whether you want to call it liberal or not, if you're preferring the longer period, you're preferring the shorter period.
Relying upon Silva cases. Would it? Do you think this is not speculation? It's not outside the record because this is just speculation about reasoning. That the Green case simply didn't consider the possibility that, in other words, your argument is inferential. I think you even acknowledge that. The court did not specifically say, you know what, 768.28 just doesn't have anything to do with this whatsoever.
Right. So the court did say, well, again, not outside the record, we all can see that the method is free to agree, not just to agree. The argument.
It was referenced in the first ECA screen.
Yeah. And then, so, but what the Green Court did do, both in a whole subsection of sitting and in its conclusion, was reject and disapprove the analysis of the Calhoun case, which relied on two things. One, the Menendez, section 95.011, any other, and two, 768.28 Owens. So I don't think it's too much belief to say that in expressly rejecting the reasoning of the Calhoun case, the Florida Supreme Court in Green, again, 15 years after Menendez, having been aware of Menendez, was great. You mentioned the reference to case,
which also rejected Calhoun.
Which also, right, exactly. And so, and in this case, I think it's significant that our trial court gave no reason for rejecting the Chapter 95 statute. The trial court really relied on this part.
Well, I was going to say, after reading RR, it's like, you know,
yeah,
do they really, you know,
but you know, what happened in RR was two things that are different in our case. Number one is the court said we're not addressing chapter 95.11/9, unlimited statute of limitations for these types of things, because actually that you don't find the cause of action had a right. So, you know, to the extent there's any question about whether that unlimited statute of actually is the case, no, I think really.
On your first issue here, and I was spent a lot of time on it, very big issue. For us to rule in your favor, we would have to certify conflict in the 4th BCA Cimarron case.
No, Your Honor, not involved in the issue. You know, I think that.
Well, but I mean, on the substantive issue, which statute applies? You can go to chapter 95 or do we use sovereign immunity statute of limitation? Because that's the first order issue we're supposed to decide. Which statute of limitation applies? You're saying it's 95/11/7. No, 9. Sorry, alternatively. Right, 9. Not 768. Court in Cimarron says no, as they break it up and say no, that's 768/28 based upon 95.0. They're reading 95.0.
Right, you know, and
I don't know how you get around it.
Absolutely, you know, distinguishable actually because one that was not they the case. Number two,
but that doesn't matter because we're talking about which state. We're still on the first issue.
But what might matter is that the alternative statute in the front and the court said that there was a, you know, I see it.
Yeah, I mean, here's what the court says. We note that the legislature intended to extend chapters 95 and 70 both individuals, government entities on theory of respondeat superior, which is what this is. It should have expressly provided as such. Instead, chapter 95 expressly bars civil actions against governmental entities which are not brought within the time period described in the court. While chapter 768 expressly requires negligent claim against the state of one of the seven commenced within 4 years of the time the action accrues.
Yeah, and
I mean, that's,
you know, and again, this is what is important. Yeah, it means you know, and in our case, we're not addressing. So we give it for now.
We're not in the only way this.
So therefore, you guys are not only way that only that. And
well, there's legislative intent insofar as it's in chapter 95, but not in 768.
And unlike the we don't have a saying we recognize it doesn't apply. So you can position A, it is even if the court were to find is not whether changing these rules
Another argument in this case is that by the time they found out about the fire, they still had a couple of years left to go.
But then they have
Right.
you know, these complications and so under the forward operating under the law was time and long term.
If you turn this argument though and look at it from a different angle, what's a little bit concerning to me is that in a way, you're saying that the waiver of sovereign immunity, which is the only way you get to the school here, that the 4-year statute of limitations there in these claims violates the right of access to it. It's a constitutional violation, which would be a statutory change, which would be a constitutional challenge to a statute, which would have to bring in the AG's office. That's not, I mean, that didn't happen, but that does seem to be the other shoe dropping on what that argument, on what argument you are raising.
Yes, and I do see that, Your Honor. Again, it is sort of narrow factually in terms of the time. Relevant. The law was having proven either.
Thank you for saying that. I'm so really fascinated. You are at 15 minutes. Actually,
okay. I'm
sorry.
To take a minute to address the issue in my investment. Essentially, okay, great. Essentially, our argument is that this is exactly the same situation that applicable should apply to. People given what follows at the time. Circumstances beyond the control, you know, in how there is inherently an ability to separate the facts and happen, and that there is lack of work. You know, we run up against the court's decision in the Hillman case, holding that until only applies to those cases, which is of course look at these from versus the general case in the district. And like, why is that? Or no, that case.
Morning. Please support my name is Wayne Dyker, Footage County School Board. First, I think it goes without saying it's always difficult when we're here talking about the rights of a child, particularly when there's things that usually certainly seriousness of any of that. But we do believe that Florida law required that the summary judgment would be entered below, that the trial court was correct to do so, and in fact compelled to do so. We also appreciate this court's focus order in the Mendez case. We believe that that case does not change our arguments, it's consistent with our arguments, but does, I think, make our argument easier. Mendez really answers the first question of this appeal, we believe. Mendez noted, as the court has noted, in key language in 95-011, which sets forth the statutory intent on all of Chapter 95, that Chapter 95 sets the time period for bringing a suit unless a different period is prescribed elsewhere. And held, Mendez held, that the integrated 4-year limitation applies to any action brought pursuant to 768-28. I think that that is binding authority. It has not been receded from the last 32 years. We believe that that conclusively answers the first question of this appeal as to which limitation applies.
Except we have this Green decision.
Right. So Green is really the only case that was cited by the appellant, and I think it's worth discussing, but I really don't think it's as troublesome as it might appear. First of all, it's dealing with a very specific situation. You know, that section of Chapter 95, 95-11-5G is probably the most specific part of Chapter 95. Deals only with prisoner claims, which is already very specific, relating to issues of confinement. It's a very particular part of Chapter 95. And the Florida Supreme Court limited their discussion to that section of the statute and came up with a decision that actually offered the sovereign more protection, limiting their exposure from 4 years down to 1 year. The case certainly did not specifically alter or amend or even mention Menendez. And I think, when we all agree that more specific tends to apply, this is a case scenario where there is a very specific part of the point. I also think it's worth noting that it was a very different Florida Supreme Court that decided that case in 2016.
And I hear you, except here's the thing about that. When you look at the two of the, you're right, there's been a little bit of a change in the guard, so to speak, but two of the justices who are still on there, Alston and Kennedy, his state law claim, this is in a dissent, partial concurrence, partial dissent, talking about his state law claim of the prisoners alleging negligent housing assignment and emotional distress relate to the conditions of his confinement and are therefore subject to the 1 year statute of limitation, section 95.11, 5G Florida statutes, in an opinion, in response to a majority opinion that ended up holding and ended up applying and analyzing 768-28.
Yeah, I noticed that it's interesting that they took the price. But ultimately, I think again they were sort of emphasizing that this is kind of an unusual situation, this is type of limitation. But since then, the court as a whole has reaffirmed its commitment to supremacy of text and separation of powers. I certainly think that the Menendez decision is consistent with the court's most recent rulings on this issue. We believe that Menendez is the controlling authority for good reason. Get back to the argument that already came up. The 768-28 is the more specific statute in this situation. SS's claim is only possible because of the limited waiver of immunity. Now that statute, it can't be brought.
Yeah, the problem with specificity is, and I saw how both sides were trying to frame the issue. One side says, well, it's claim specific, and the other side said, no, it's really more party specific. That canon of how you figure out, or that thread of law, how you figure out which statute of limitations applies, it just depends upon what point of view you want to look at specificity.
Specificity is tough.
It's a hard rule to apply because it's almost never the case where one side can't say something about their claim that would make it more specific to them. So I don't really know that helps us, but I am interested in your thoughts on 95.011. About what that has to say, because that has changed and that's still out there.
Well, I think 95.011 sets the tone for this whole discussion. I think that's really the authority behind Menendez, is that they're saying, that chapter 95 only applies unless there's another limitation elsewhere. That's exactly what we have here. I think you're right. Specificity is tough, but we just have to look to the language of the statute. We have to keep coming back to the language of the statute. We come back to 95.011. And we look at the legislative intent as expressed in 768-28. If the legislature had intended to provide more waiver, if you will, for victims of child sex abuse or battery, they could have incorporated that in the 768-28 14. They've tinkered with that statute.
They made them out.
Right, and now a contribution. So it's certainly not unusual that they have decided this isn't the effect that we wanted. Go back and they let the statute. I think that because the legislature sees 768-28-14 as the gatekeeper of this process, just as the Menendez court did, as this court should. Assuming that the 4-year statute applies, access to courts is a fundamental right in Florida, but it is not a guarantee that all things can be brought at all times. Just because there are limitations periods and sometimes short periods, that doesn't mean there's a deprivation of access. And although it's an unfortunate situation, we know in this case that SS was not deprived of access to the court. Despite late discovery, she was aware of the alleged abuse for 2 years. She became aware 2 years after the last act of alleged abuse. It still had 2 years which to bring a claim against the school board. under 768-2814. And in fact, SS retained counsel within that time period are very close. The record is a little bit vague on exactly what day, but very close to within that 4 years, she did retain counsel and filed a notice of intent to sue. So access was available. I think that the RR case is very helpful here in that it sets forth, the rules for rule and for polling in Florida. I don't think, since the legislature, what the court said in that case is since the legislature has gone to the trouble and they have adopted a very extensive and unambiguous statutory scheme, that there's just no room left for common law rules. There's really no argument here. SS is not arguing that any of the statutory provisions apply. So because that argument doesn't exist, you have to resort to a constitutional issue. And in doing so, challenges the RR case. And one of the, or maybe the only way in which that's disputed is that this argument that the court, Florida Supreme Court and RR did not consider access to courts. We can debate whether or not the mention of access to courts in the jurisdictional branch of the court is important or not. I would suggest that the entire RR opinion is about access to courts. If you read just the first paragraph of that opinion, it seems to make it exceptionally clear. We can't assume that the Florida Supreme Court ignored a fundamental constitutional right in setting out this comprehensive guide to how limitations work in Florida, separation of powers, the role of the courts in that process. It wasn't discussed because it wasn't an issue, just like it really shouldn't be an issue here. I think for this court to find a deprivation of access to courts, they have to sidestep RR, Menendez, and most of Chapter 95 to do that. I think that SS in this case has not really cited any authority to suggest there's a constitutional violation. It's interesting that the RR case actually presented potentially a stronger case for deprivation of access to courts than this case, because in that case, one of the minors' parents did not find out about the abuse during the limitations period, and it ran. And the Florida Supreme Court said the period started, it ran, the case was time barred. So that being the case, I don't think the facts of this case, where SS actually had knowledge within the limitation period, that would be unlikely to sway the reasoning that the Florida Supreme Court utilized in the RR case. It's certainly true that public policy generally favors victims of sexual abuse. There are competing policy concerns. Public policy also favors a limited waiver of sovereign immunity and a finite period for those claims. Again, I would just suggest that if the legislature intended to waive more immunity, they've done so many times, they could do so again. Just to briefly address the issue of equitable polling, I really don't think, again, if we accept the ruling in RR, equitable tolling is one of those special judge-made rules, common law rules on top of statutory rules. The court said that there is just no room for.
There's a little bit of an irony in the context of this case, in that RR was kept continually talking about the minimal role of courts in fashioning statute of limitations and fashioning and 768-28 as a waiver statute came about in response to the common law of sovereign immunity.
Right. Yeah. But I do feel like that the RR court, the Supreme Court opinion did a good job of sort of articulating all of those ideas and discussing the interaction between the common law and statutory law and the separation of powers and how that works in Florida today. Unless the court has any questions, in light of Menendez, in light of RR, we believe the law is clear. The claims are time barred. We respectfully request this court to affirm the summary judgment. Thank you.
briefly, Ron, that normal. It's our position that the green case did from widely.
Okay, so there's and I know you know this, there's Florida Supreme Court case law that says the Supreme Court does not implicitly or impliedly receive from a prior case. Now, I think it is fair to say that it looks like Green just doesn't really mention Menendez, or at least doesn't seem to tackle Menendez directly. In other words, they're not tackling their own precedent, and maybe maybe that's something the Florida Supreme Court should consider.
But what the Florida Supreme Court did in the Green case is say, number one, unless the claims fall under Section 95, the Florida Supreme Court the precedent is more specific. And about the specific means, but it's say 95 falls to any other statute. The left, Section 95 applies where they were passed. The second thing is the Green case that the whole paragraph of the Green case that says the Calhoun Court did two things. Both of those were wrong, but they reached the right result. And what the Calhoun Court did is citing Menendez as point number one, this 95.011 thing means we're going to go anywhere else, any other statute. And number two, 768.28, always people making so when the Supreme Court says we disapproved the analysis of the 5th district, and we disapproved the reasoning of the 5th district, when the action support is due, I think the key is what the law was. It's not whether our client has 2 years left or a day or a week or 0 days left, which is not aware. It's at that time, the law was the cause of action is not approved. And those conflict cases did not arise. So the Florida Supreme Court, in the RR case, did not decide this action. Again, they listened to the issues they were talking about, and the idea that they were inherently always address action support, and then I think ignores the fact that action supports the state. Right? You can decide not to raise the issue and have to put in on the other issue, and not because the board did have actual notice in the case within the 4-year period because of the complaint that was filed. So there would be no prejudice, and also would be none of this public policy reasons of making sure that the government is not overexposed to the
Thank you. Other questions from the case? Thank you both.
All rise.